Hello, my name is Macron. This video is about purchasing your home in New York. I've been an attorney for 32 years, and people come to me all the time to represent them for purchase of homes and selling their homes. And the one question that everyone asks is, what is the process? How does it work? And this video on purchasing your home in New York is part of a series of videos that I've prepared to assist the public in understanding the process of buying your home in New York or selling your home in New York, and buying a home in New Jersey and selling your home in New Jersey. Purchasing your home in New York. Get a home inspection prior to entering a contract of sale. Now that you've found the home that you want to buy and you need to engage the services of a home inspector, this is to be done before entering the contract of sale. Unless you know whose services you want to use, ask your realtor or simply go on the internet and conduct a search for a local home inspector. The inspector will prepare a report summarizing his findings about the building, such as structural conditions, roof, basement, plumbing, and electrical systems. Consider being present for the inspection when it is performed. Have a termite or wood boring insect inspection done as well. In certain areas, a radon inspection is performed. Ask your inspector if a radon inspection is necessary in the area that you're purchasing. Once you've received the report, forward it to your attorney. Discuss with your attorney the repairs you wish the seller to make. Your attorney should include the desired repairs in the contract of sale. The next step is the contract of sale. The seller's attorney will prepare the contract of sale and send the proposed contract to your attorney. Review the terms of the contract with your attorney. Let your attorney know if any terms are unacceptable and any terms you would like added. Expect to sign 3 or 4 copies of the contract. In addition to the contract, you will need to send a contract deposit to show the seller that you are serious about purchasing the property. The deposit is typically 5 to 10% of the sale price, although it can be more or less than that. It will be whatever is negotiated. Understand that if you materially default on your contractual obligations under the contract, you could forfeit your deposit. It is for this reason that sellers always want as much of a contract deposit as they can get, and why a buyer wants to put down on contract as little as possible. Your attorney will then send the signed contracts and contract deposit to the seller's attorney. The seller's lawyer will then review the contract with his client. If all is acceptable, the seller will sign the contract. Will sign the copies of the contract that you have already signed. You are now in contract or under contract. The seller is now contractually obligated to sell the home to the buyer, and the buyer is contractually obligated to buy the home from the seller. The seller's attorney will then send 1 to 2 contracts back to the buyer, or rather the buyer's attorney. The seller's attorney will then deposit your contract deposit into his attorney trust account. That money will remain there until the closing. Next, you must obtain a mortgage commitment. Assume that you do not have the funds to buy the property with cash that you have on hand. You will seek to obtain mortgage funds from a lender. Of all the things that you must do in the home purchase process, this is perhaps the most important obligation you must fulfill as a buyer. Intentionally failing to submit to the mortgage process is a material breach of the contract, and you risk losing part or all of your contract deposit. A lender will request financial records from you, such as tax returns and other financial records. You may either approach a bank or use the services of a mortgage broker to apply for purchase money funds. This process can take 30 days or more. Be patient. Once a lender has agreed to provide you with mortgage funds, you will be issued a mortgage commitment. A mortgage commitment is a promise from a lender to provide you with a certain amount of money, specifically to purchase this home that you are in contract to purchase at a certain interest rate over a certain period of time, typically somewhere between 15 and 30 years. Once you receive the mortgage commitment, you must send a copy to your attorney without delay. Your attorney will then forward it to the seller's attorney. Contractually, you are obligated to send the mortgage commitment to your seller's attorney. It lets the seller and his attorney know that they have a real buyer and this transaction is moving, in fact, toward conclusion. Your attorney will then order a title report from a title insurance company or from a title abstract company. The title company will perform research on the property, determining who owns the property and whether there are any judgments or liens that need to be paid off. in order for the seller to transfer the property to you free and clear of any judgments and liens. These items are compiled into a title report. Your attorney will go over the findings of the title report with you. Once these issues are addressed by the seller and any judgments and other items against the buyer are cleared, and the title insurance premiums are paid by you at the closing, the title company will issue title insurance for the property at the closing, ensuring you clear title. The next and last step in the closing process is for you to obtain homeowners insurance. It is often overlooked. It's forgotten about because you're so wrapped up in getting your mortgage commitment that homeowners insurance falls through the cracks. But remember, the bank will not release any funds until they are secure with insurance. This is also called fire insurance. The bank wants to know that in case there's a fire in the house, that they can collect the money that they've loaned you back. And at the closing, they will not release any funds until they know they have homeowners insurance. Make sure you obtain that beforehand, well beforehand. The final step is the closing. The moment you've been waiting for patiently for months has arrived. Make sure you bring a pen, preferably black, your valid unexpired driver's license, and a secondary form of identification. At the closing, you, your attorney, the seller, and their attorney will be present. Also present will be the title closer and the attorney for the lender. The realtors involved in the transaction are usually present as well. The title closer will make copies of the driver's licenses, collect all the title insurance premiums from you and other title fees, including the seller's transfer taxes. The closer will also collect transfer documents such as the deed, transfer tax documents, and affidavits. The closer typically notarizes any documents that are sworn to by the parties. Once the mortgage documents are signed by you and the lender's attorney is authorized by the lender to disperse the mortgage funds, the funds due to the seller are given to the seller in the form of a bank check or a wire minus the seller's closing costs. In exchange, the seller gives the buyer a deed transferring the ownership of the property to the buyer. The original deed is then taken by the title closer to be recorded in the office of the county clerk where the property is located. Upon recordation, the recorded original deed is then returned to your attorney or to you. The transaction is now closed and you now own the property. Congratulations.